you sure? You want to just have it with you?
Sure, you could put it there. We'll figure it out.
Keep me on my straight and narrow there. All right.
At the Ritz?
Everybody ready?
Isn't that the Marriott? Used to be? Yeah.
All right. All right, this time I'd like to call the work session to order on November 2nd, 2023. I, Martine Zarinskis, will be serving as chair for tonight's meeting. So thank you for watching and joining us. We have a full house. Roll call, just to make note that we have both of our alternates present tonight, and the chairman and Commissioner Perkins are not here. And Katie Rocco as well, so 3. And we have a presentation from the city attorney.
So she's been with the city a year and a half, and we have enjoyed working with her tremendously. And just, you know, as always, our city attorneys help us to, when we have questions, legal questions, and we're looking at, you know, certain conditions can we place on public hearings, and so she's just been kind of like our right arm and very helpful. So I thought it would be great if she came here tonight, because there were some questions over the last 2 meetings about things that we can ask for, things that we cannot ask for. So I thought it would be good if she just came in and gave just a brief summary of zoning law. I guess it'll just be a very condensed version of zoning law and what we should be looking at as we look at these public hearing applications. I'll turn it over.
Thank you, Kathy. As Kathy said, I'm Molly Eswine. I think I've met most of you, but this presentation that Kathy asked me to give is actually a training that I give to several planning commissions that my law firm represents periodically. And so this is a little bit more condensed version, so I'm not going to keep you too terribly long today, but it just kind of goes through some of the procedures that Alpharetta has. I've got some things in here for zoning conditions, generally for providing you with guidance. And of course, if after today's work session you have any questions, you can either reach out to Kathy and she can put you in contact with me, or you can reach out to me directly. Either way is perfectly fine. So that's just for fun, just a little picture of, it's not showing? Is it showing? Oh, okay. So, oh wait, you see a roller coaster, right? Oh, oops. Such a cute picture. Well, that was the day I got engaged. How do I get it to connect? Can I get some help?
It is connected, so you might have a dual screen on.
I don't. I'm sorry, y'all. Well,
It's good to see that she has, looks like she has. I'm here.
thank you.
And I'm not going to be technically probably proficient.
So y'all just thought I was fishing for compliments on my picture with my husband. How about that? That's funny. So this is just, not that we need it now, to lighten the mood. Why zoning is important. Obviously, nobody wants a roller coaster in their backyard, and so I just, put these in here for fun. So that doesn't really have anything to do with training for y'all, but there you go. So Alpharetta zoning procedures. So the reason this is important, the reason following our procedures is important internally is because that is something that the courts take into consideration. If we violate our own internal procedures and someone were to challenge an action taken with respect to our zoning, our exercise of zoning as a city, then that challenger may actually say, well, you know what, the city didn't follow its own procedures with respect to my application. Or if, say, we were to approve something that a neighboring property owner didn't like, they might actually say, well, they approved it, but they didn't follow their own procedures, so their decision is null and void. Now, that would be a due process question, and it might just mean that we have to come back and do it all over again, which is more of a hassle than we want, but it could lend itself to other issues as well. And so the point is, and what this excerpt gets to, is that the courts have repeatedly confirmed that they are going to require strict compliance with the requirements of a local government's zoning code with whatever procedures that individual government has required of itself. So the zoning procedures law at the state level requires some minimum procedures, but we get to exercise the zoning, we get to say what the zoning criteria are for the most part, and that's what these cases say, and that's why it's so important to make sure that we're constantly refreshing our memory as to what the UDC says, what our procedures are, not just as a planning commission or city council, but also with staff. Staff is constantly going back to the UDC, making checklists, refining their checklists, and making sure that they're following everything to a T so that when we make our zoning decisions, we have them on as solid a foundation as possible so that hopefully when we get to court, we're only fighting about whether it's a constitutional zoning designation or what particular restrictions we've placed on the property rather than procedures. So within our procedures, we have section 5.3 of the UDC, which is what establishes the Planning Commission as a recommending body to the City Council. And then in Article 4, it outlines all of the procedures for having a public hearing, what the criteria for a zoning is, and how that guides the decisions by both the Planning Commission and the City Council. So the Planning Commission recommendation, it is set forth in section 5.33, which is where, as I said, the powers and duties of the Planning Commission comes into play. Paragraph A provides that the Planning Commission holds the public hearings on all applications for zoning changes, including concurrent variances or exceptions. And so Section B provides that you are the body that hears and has the public hearing with respect to comprehensive land use plans and text amendments to the UDC. So if we're going to make a change to the UDC, you hear it. If somebody wants to change the comprehensive land use plan, you hear it. And for all zoning decisions, and I know you all know this, but this is where it comes from. So we're just starting with the base framework of the UDC and building up. That's constantly what we're doing with this. In chapter 4 of the UDC, we see exactly what the Planning Commission's powers are. So when you take action, the UDC says, with respect to the comprehensive land use plan amendments as well as the zoning decisions, that you can either recommend approval or denial. With respect to the zoning, you can specify conditions, or you can actually ask that the City Council refer it back to you for further action and consideration if you think a project needs more work. So that is the allowance in the UDC for the Planning Commission. And everything that you do, all of the things that you consider, everything you say that are reflected in the minutes, everything that's said at the public hearing, and all the materials that you look at go to the City Council. And that's to perfect that record so that when it comes to defending ourselves in a lawsuit, we see the whole picture. The City Council got to see exactly what you got to see, as well as what they had at their own public hearing, and that's contemplated in the UDC. So in taking final action on an application, the city council actually has a little bit more authority because they can approve with conditions, and they can reject, they can allow for withdrawal, they can table applications, and then they have the power also, even if you send it back or send it up to them with a solid recommendation of approval or denial, the city council can send it right back to you if they think it needs more work, even if the planning commission doesn't necessarily think it did. So the decision criteria for both the city council and the planning commission is the same. And so we have standards for the comprehensive land use plan amendments that when we have a comprehensive land use plan amendment application, there are criteria in the UDC that are mandatory for us to consider. And so that's what is right here. And when we are considering those applications, we're supposed to limit the consideration to this criteria. This is what the city council, in adopting this provision of the UDC, has said is what the city council, as well as the planning commission, should be considering. And so I'm not necessarily going to read them all to you right here, but I'm going to give this presentation to Kathy so that you have it kind of as a quick reference rather than having to flip through the entirety of the UDC, but you can see exactly what that criteria looks like. So what kind of demographics we have, what changing conditions we have, to the extent that it would impact the health, safety, and welfare of neighboring properties, things like that are what we are allowed to consider for the comprehensive land use plan amendments. With respect to zoning changes to the zoning map, even if it's to a specific property, then we have to first look to see that it is in conformance with the comprehensive plan. And that's something that staff is going to do as a threshold matter. Though if you go to the criteria for consideration with respect to a zoning amendment, whether it is compliant with the comprehensive plan is still a criteria for you to consider. So that's something that's being caught at the first level of review with staff, but it's still also in the list for you. And so, again, it says that the city council shall consider the following standards. And that's something that when I'm looking through a zoning lawsuit that somebody has filed against one of the governing bodies that I represent, a lot of times you'll see that they make allegations that the city council or the board of commissioners or the planning commission failed to consider the factors and the criteria that they have established in their own procedures. So they'll say that, well, they looked at wholly irrelevant criteria, things that weren't set forth in the zoning standards in the UDC, and they'll make that argument. And so this is not just for us, the public is looking at this too. I'm sure you've seen, you might have some particularly interested citizens who will pull this language and put it in an email and say, this is why you should deny or this is why you should approve. The zoning applicants are doing the same thing, and the zoning lawyers who are going to challenge us are doing the same thing. So try and look at these criteria and really critically think about them when you're sitting up here hearing applications and making your comments. It's not absolutely necessary that you say anything with respect to these, but do look at these, review them. I know they're in the staff report for you to look at to see how staff has answered them, but it's perfectly appropriate for you to look at them and consider them as well, and actually you're supposed to. So, and it's A through I with respect to the zoning amendments. So these are the types of issues that you are authorized and empowered to look at as planning commission members. And they're actually still fairly broad, but it all focuses on land use and what the appropriate use of the land is, how it's affecting neighboring and adjacent properties, how it's impacting public facilities, infrastructure, whether it's a reasonable balance between the interests of the property owner and the interests of the neighboring properties. So just like with the comprehensive land use plan and just like with zoning, we have criteria for conditional use permits. And so you might actually get an application where you have to look at every standard for all of them. And that's perfectly appropriate. You might want to approve a zoning and not approve the conditional use permit because the criteria for the zoning makes more sense than the criteria for the CUP, and that's perfectly appropriate. But that's why we have different factors for consideration for the different types of applications. So again, I'm not going to read them all out loud to you. There's no point. I know y'all can read, but I thought this would be maybe a handy little list that you could look at when you're considering these. With that, I'm going to move into zoning conditions. So zoning conditions are perfectly legal under Georgia law. They are more often than not something that we impose for every zoning that we see. they're intended to ameliorate the effects of a zoning. So when we are rezoning a property from one district to another, what is the impact that that zoning is going to have, and then how can we lessen that impact? That's what the conditions are supposed to do. So do we put in a buffer? Is that going to lessen the impact to the neighboring property owners? Are we going to, require a berm? Are we going to specify delivery hours for commercial enterprises? Things like that all are intended and are aimed at lessening the impact of the zoning. And so it should always have a relationship to the likely impact of the rezoning. From time to time, you will see an applicant come in and say, oh, well, I'm willing to do X, Y, and Z, and it doesn't really have any impact on the zoning itself. Technically speaking, those kinds of conditions, even when proffered by applicants, are not in accordance with Georgia law to the extent that they are not ameliorating the effects of the zoning. And so I always say to approach those with caution. Kathy and I've actually discussed them from time to time. I've discussed them with various planning directors that I represent, and it's always, something a planning or a zoning applicant may be trying to offer to sweeten the deal, even though it's not, again, actually intended to ameliorate the effects of the rezoning. And so just keep that in mind when you are looking at conditions and trying to craft something to basically address a concern that you have with a zoning. I think 9 times, really 99 times out of 100, when you are thinking about, okay, I want to do this, it is because of the zoning. It is because of something that the zoning is causing that you're looking at doing that. But always question that, look at it critically, and make sure that that's actually the case. The other aspect of conditions that I'm always going to recommend is consider how they're going to be enforceable. And please always feel free to ask me or staff if you think it is enforceable. A condition is only as good as it is enforceable. If we are putting these lofty criteria in a zoning condition that nobody's going to be able to track, nobody's going to be able to enforce, then it's not worth anything more than the paper it's written on. So the more we can make a condition enforceable, the better we are going to be. So conditions should be clear. Staff does a great job of drafting the conditions and putting them in the staff report for you, but I know that sometimes the appointed and elected officials might want to tweak them or add something to them. So to the extent that you can work ahead or think about it ahead of time, so that you can work with staff to make sure that they're sufficiently clear if you're going to make a motion to include an additional condition or two, I would recommend you do that. That way, when staff has the report to send to City Council of what the Planning Commission recommended, the condition has been fleshed out and is well thought out ahead of time rather than during the meeting. Now, sometimes that's going to be unavoidable. The whole purpose of having public hearings is so that we can receive that input from the public, and you might hear something that staff knew nothing about during a public hearing, and it's going to require some quick thinking to get that condition in your recommendation, and that's perfectly fine. It's just to the extent you can, work ahead of time with staff so that they can flesh it out, all the better. So the reason for asking for that kind of forethought is that when there are ambiguous conditions, if there's any level of ambiguity, then courts that are looking to enforce the conditions are always going to construe them in favor of the person against whom they're to be enforced. And that means that if there's a way to consider it in favor of the government or a way to consider it in favor of the property owner, they're always going to favor the property owner in that. It's the same for ordinances as well. If there is any ambiguity, it's construed in favor of the person against whom it's going to be enforced. And so to the extent we can make them lack any ambiguity, all the better. Then we don't have to argue it, and we don't have to try and finagle that with the court. So again, try and prepare your conditions ahead. One way of thinking about it is to try and think about them without knowing what you know right now. Look at what the condition would look like to someone reading it 10 years from now, because conditions run with the land, and the people who are looking at this condition 5 or 10 years down the road are not going to be coming back and listening to your planning commission meeting video or the city council meeting video. They're going to be reading it as it's in the city zoning file. And so if there's context that needs to be added, if there's detail that you understand but may not be coming through the other conditions, feel free to go ahead and add that in, and that way later on down the road we'll know what that is. Try not to duplicate rules in the zoning code. I know Kathy and Michael are really keyed in on those, but there is a time and a place, depending on circumstances, for duplicating that. But generally speaking, you don't need to be duplicating what's already in the UDC. And then one that has come up fairly recently is not to add conditions that require activities on other properties. So we are looking at a property that is in front of us, the parcel of land that is before you for an application, and we can't add conditions to a property that's not properly before you as part of an application, whether it's because a neighbor has complained and wants them to put a fence on their property, or it's a different property that they own that has code violations. It doesn't really matter the circumstances. If it's not the property that is in front of you, it can't be conditioned. Now, we can certainly encourage, if the neighbor who has an issue wants something done on their property, then the neighbor and the applicant can try and work it out, and they can come to some sort of an agreement, but it doesn't need to be the city council or the city planning commission facilitating that necessarily, and certainly not as part of a zoning condition, because that would not be enforceable to put a condition for an applicant to do something on somebody else's property that they don't own. Consider the number of conditions and the intensity of the use. So does a 3-acre zoning require 55 conditions? Maybe, maybe not. It depends on what they're going to do with it, right? And so just try and keep things proportionate to the impact. And again, it all comes back down to how is this intended to ameliorate the actual zoning, the land use, not necessarily every aspect of what's going on the property, but just the use of the property itself. It's possible that the UDC is going to address some aesthetic concerns or conditions, so different overlays, different districts may actually require certain design criteria and might actually even require more to be submitted to staff for an application. And so it's important to keep in mind what those districts require and what don't. Because we can require things that the UDC requires in certain contexts, but not in others. And so it all comes down to what I was talking about earlier, that framework, because we have a framework not only for the Planning Commission and what y'all consider what the criteria is, but also what the applicants are required to provide. And so when in doubt, ask staff if we're allowed to ask for or condition the elevations and the renderings, then great. If not, then we have to keep our view isolated on the land use and the criteria for the zoning as provided in the earlier part of the presentation. The trend a lot of times is to use zoning and the Planning Commission and the City Council as a full site design when that's not really the intent of zoning. Now we have certain provisions again in the UDC that does that for us, and we regulate them to some extent that way. But when you have an application that is strictly for land use, you need to be looking at it strictly from a land use perspective and the impact that that use is going to have on people, so that you're following the UDC and you don't get a lawsuit where somebody says, well, they considered things that were outside of the criteria that's listed in the UDC. I've got this for meeting efficiency and meeting procedure and efficiency, and this is really quick. It's just my little 2 cents on making sure that y'all are operating kind of according to the law, apart from open meetings, and that is the entirety of your meeting is intended to foster confidence in government and to make sure that we're getting the job done that we are tasked with doing. And so we need to make sure that we are acting with proper decorum, making the public realize and see that there is actually a level playing field and that we are here to hear from the public as well as the applicants and have respectful discourse among ourselves. So just would encourage you to be tough on the issues, not each other, not on the crowd, not on the applicants, but tough on the issues themselves. Be willing to listen and hear them out, and just remember that somebody is always out there watching. And I know that sounds like I'm Big Brother, but your meetings are recorded. There's always going to be somebody who's watching, and so just bear that in mind so that you're allowing for those respectful views. So I'm going to skip this part, and essentially the final thoughts is, as I said, the trend in the zoning process is to have more detail right now, and that's more than it's ever been before. But again, that's not really the intent. The intent is to look at it from a land use perspective, not a design perspective. Personality should never be a part of your process. Don't be afraid to get the applicant to agree on the record to the conditions that they're asking. And if they proffer conditions, that's perfectly fine. I know I cautioned against that to an extent earlier when it wasn't about ameliorating the effects of zoning. But if it's to ameliorate the effects of the zoning, by all means, if they want to agree to a condition, even if it's a condition for design that you wouldn't otherwise be allowed to ask for, if they offer it, that's okay. Because then, that might be for the amelioration of the zoning. It really is going to come down to a case-by-case, a property-by-property basis. And of course, if you're uncertain, always defer to staff. They know this like the back of their hand. So if y'all have any questions, I think we have a few minutes before the next meeting, but otherwise, it was great to see you all. And again, you can always feel free to reach out to me if you have any questions when anything comes up. Thank you.
Anybody have any questions? Thank you very much. We appreciate the time and the reminders. And Kathy, you'll get this presentation available for us and the members that aren't here. Great. Thank you. Appreciate your time. So with no further business, we are now adjourning the work session.